Hello everyone. Continuing with the topic of the inventive step that we have discussed in the previous slide. So here we are continuing with the next step that we have discussed in order to know better about the inventive step. So here, if you're considering prerequisites, we have already discussed this. If there is some doubt, we can discuss it. But for the time being, I'm skipping these slides as we all know the need, the importance, the implementation issues in the law. We have discussed it several times. Moving forward with the objectives, let me tell you one major important topic objective of this particular slides of this particular topic is to make available about the knowledge, or is to make you aware about the knowledge of the patent law and specifically the inventive step, so that you will understand the concept well. Moving forward with since we have discussed everything before, so the fourth step in this windsurfing approach is where the assessment is obviousness is made. So in fact, when you're talking about the fourth step in the critical question, the first three steps merely laid the ground for following. I told you four steps in the first slide, in the previous slide. Let me revise you all those steps here. The first step is talking about getting your things patentable. The second step is talking about to know what prior arts are available in your field. Third is comparing those arts with each other. Fourth one, and the important one here, is that you are basically trying to compare your art with that previously published art. Why? Because you need to know what all things are new in your slides. So in order to know that, let me tell you the fourth step here in this approach of windsurfing approach that we discussed, the four approaches. The fourth step is little critical. Why? Because the first three steps are basically trying to give you the groundwork, or merely laying the groundwork that is final for the final question. But the fourth step is making you understand what all things are considered without the benefit of the information available after the prior date. And then when you are talking about the fourth step, one must guard against the ex post facto analysis, because this would be unfair to those inventors who have already invented the things beforehand. Now, moving forward in the fourth step, the inventions must be compared against the whole of the state of the art, comprising all the relevant pieces of the prior art. Moving forward, courts here sometimes imagine a hypothetical skilled addressee standing in the workshop, surrounded by all the relevant papers, publications, and other prior art references, but only those who have been obvious to use in the first place. The question then becomes important here. So now, moving forward with this, we will here try to understand the question that becomes important, that would such a person that would such a person who is confronting the problem solved by the inventions and aware of all these references have found it obvious to make the claimed combination. Now, thus, unlike in the inquiry for the novelty, it is permissible to construct a mosaic out of the various pieces of art in the inquiry for the obviousness. So, in order to know that, there is, however, an exception created to this particular scenario for the fourth step that we have just discussed in the windsurfing approach, where the assessment is obviousness is made. So here, mosaic is not at all permitted in the previous obviousness inquiry if it would be not obvious to the skilled addressee to mosaic the different pieces of the prior art. I hope this is clear now. So now we are talking about the obviousness of the thing. So to know that obviousness focuses on the difference between the claim and the prior art. So here I'm again and again telling you, you would be comparing your product with the previously available products. So here, when you try to understand the obviousness of a particular thing, you will try to understand how this claim and the prior art would be there for each other, and ask whether these differences are really inventive or whether they are differences that might have occurred to anyone of the ordinary scale. So in order to know the obviousness, you will be understanding the obviousness that focuses on the difference between the claims and the prior art. Here, non-obviousness should not be confused with the complexities that arises while filing a drafting application, and sometimes the simplest inventions are more innovative. Maybe your machine that is of higher values cannot be an inventive step, but your innovation can be. So not must be the invention embrace a flash of genuineness, and also the kind of sudden inspiration that leads to the Archimedes principle or anything that relates to the day-to-day life. Also, when you talk about inventions, that is the product of the patient experimentations that is discovered entirely by the accident, is just as patentable as one that arises from the pure mental efforts. So just remember, when you're talking about the invention, when you're talking about the obviousness, here you're talking about the mental efforts. After that, we can also say that patentability is not affected by the manner in which the invention is made. It is no easy task to adopt the perspective of the different persons. So a person of an ordinary skill in the art, you have no right, you have no skill to know what this actually mean at a different time. So the time the invention was made, so one can easily fall prey to the hindsight. Moving forward, once you have seen the invention and how it is resolved the problem, it may seems to be an obvious thing, but it cannot be in the day-to-day life. So the ingredients of the solutions were already available. You cannot say that your invention is a valid invention. So here, in order to understand the basic idea that actually talks about the inventive step, you would be considering it by comparing your claim, your application, your drafting file with the prior art in that particular field available. Here we are focusing on the prior art again and again because your invention will only be patentable when that particular thing is not available in the public domain. And whenever I'm using the word public domain again and again, here I'm talking about the prior art that is available in the entire world. So here, moving forward, when you try to understand the invention, you you will be simply be surprised to know because the component parts already exist in the in the past, your invention will not be patentable. So if you talk about such things, one cannot prove the obviousness of the combination of A or B or C by showing that A had already existed, so that B and so that C, and you're combining each of them. So in a similar thing, a Federal Circuit Court emphasizes that the standard of obviousness is not whether something would have been obvious to try. So concerned that worthy invention might be held obvious simply because their components already exist in the market or already exist in the public. So one cannot prove the rearrangement or the obviousness of the combination of a particular thing that we have already studied under the section 3 of the Patent Act. Like if there are two products or if there are four products, let's take an example of the products A, B, C, D, and you are merely making it a combination of that particular products that have already existed, and so now the obviousness of such product cannot be proved. So one has to show, the person who is filing the application, the person who is filing the claim. If I'm using the word claim again and again, here I mean you are getting your products patented. So you need to show that ordinary scale person, if that a person would combine the products A, B, C, and D, it will not become obvious in such cases. There are various cases that has proved these points. Now, instead, one has to show that the invention was so obvious to do that a person of an ordinary scale would have proceeded with a reasonable expectations of this success. Now, moving forward with one of the very important case, that is KSR International Corporation versus Telefix Incorporation. In this case, what happened was there was this bicycle pedals which gets adjusted through your height. So height adjustable accelerator pedals equipped with the electronic sensors were asked for the patenting thing. So there was the finding that these all things were already existing in the market, but all these things, when electronic sensor, when then pedal, when then height adjustable accelerator pedal was combined with together, it's giving you the new thing, it's giving you the new idea. So basically, to understand it, this case here becomes important. Moving forward with this, also an appeal in the Supreme Court. Moving forward with that case that we were discussing, KSR International, the appeal was filed in the Supreme Court, and then what happened in this case was the combination was considered to be the non-obvious, but because of the synergy that was very unexpected, perhaps a perfume combined with a sunblock producing and creating an unexpected mosquito repellent. In the same way, perfume and the sunblock has been existing in the world, but when they combine, it gives a new combination. So the electronic sensors were becoming standard, so eventually that person's skill in that particular art would add them to be the adjustable pedals, just as a patentee had done. So the court also observed that the combinations were more likely to be obvious if they consist of known components performing the unusual functions. So in this particular case, using the example of the perfume added with a known sunblock, each behaving as one would expect. So in KSR case, the sensor and pedal in combination produced nothing more than the sum of the parts, the synergy of the parts. So Supreme Court found that the teaching suggestions and motivation tests that had been applied too woodenly in this case. So any person with a common sense that the improvement did not arise to the level of the patentable invention. So this is known as common sense, the new test that was evolved with time. So in this particular case, that was merely considered to be the combination of the two products. Their components, they consist of the two products that were already known, performing the usual functions, as on the other hand, a combination might be non-obvious if it creates some different type of synergy, an unexpected synergy which was not done in this particular case. Moving forward, although the obviousness that was involved in this particular case, or the pedal along with the electronic sensor cannot be patentable. Moving forward with another case, that is known as in re Gorman case, again the US based case. What happened in this case, the Gorman's claims were very detailed and none of the references included all those things that the Gorman claimed. The patent office found that the combination was still would have been obvious if any person with the ordinary scale would read that. So they basically trying to claim an invention on the lollipop in the shape of thumb. So here the claimed invention that was in the shape of lollipop and the thumb, the element of the claim of the invention was the thumb shaped candy, the protective covering of the thumb shaped candy that is used as a toy and novelty for the replacement, and there was a stick that is attached to the lollipop. The prior art located by the patent offices was given the 13 types of references. Some type of references showed that such type of candy or ice cream is already available in the market along with the wrapper of that product. One ice cream product on the stick included a similar cardboard base Other references disclose that thumb-shaped candies and confections were not there in the market. So although all those references were not there, these points were discussed, these elements were discussed, were there in the patent application. So the various elements that were combined by the government, all combination used in the same way for the same purpose for the claimed invention. So here this was not considered to be the valid invention. Moving forward with the another case which is very important here. When you're talking about this case, that means the name of the case is Molecular Research Corporation versus CBS Incorporation. So in this particular case, the court upheld the determination that the claimed invention was not obvious. So here I'm giving you the example of this particular thing. So here they were basically trying to get a Rubik's Cube puzzle that was popularized as the Rubik Cube to be as patented. But that thing was the infringement for the Rubik Cube. So their invention was the cube puzzle for the kind popularized as the Rubik Cube. So here they're trying to understand the puzzle in the shape of subdivided cube, the piece of which could be scrambled and stored by the rotating the facets of the cube. So here in this particular case, in this particular application, the evidence showed by the person while considering those shapes has been dismissed as a cube was inadequate. Moreover, the lower court properly concluded that even someone who was aware of the sphere would not have found it to be obvious. So in this particular case, the invention was considered to be non-obvious and this could be patented. Moving forward, under subsequent federal precedents, secondary considerations have been mandatory aspect of such obviousness analysis. Secondary considerations include the following: commercial success, failures of others, near simultaneous inventions. So the secondary considerations most frequently encountered is commercial success. Commercial success gives you various ideas that we have discussed in this particular slide, and an invention that has been successful in the marketplace could have been an obvious one. So these are the references from where I have collected the material. You can find the other material in the Spicy IP or the SEC online as well. These are the links, these are the textbooks, and thank you for today. Thank you for listening.